I've just been showing the court bits of paragraph 56
Yes,
of the judge's judgment. Can I just go back very briefly to a paragraph that I went halfway through but didn't take you all the way through, which is paragraph 56, subparagraph 4. So this is in the judgment, which is in the core bundle at tab 5, page 57 and 58. And you'll have seen from the passage I took you to earlier, and Mr. Patton took you to some of this as well. I made the point before the short adjournment that the judge prefaces these subparagraphs by saying that the cross-examination of both experts had revealed a good degree of agreement, and then he sets out these conclusions. And in the middle of subparagraph 4, I read, I think, before the short adjournment, the first sentence. I just want to take you to the next bit, because then I'm going to show you what the indications were for the relevant rules for Narapple. In 2012, it was considered that HRD cancers were particularly sensitive to treatments involving platinum. Therefore, a good response to platinum treatment with a possible indication of HRD that came with it, that's important, was an example of the medical or scientific procedure involving identification of HRD that was set out in the specification of the licensed patents. And just before I take you to the indications as pleaded, one more paragraph only on the scope of the licensed patents, just to make good a point which I did make earlier but without reference to the judge's judgment. Paragraph 44 at page 55. So the judge has set out at 43 some of the issues that have been identified by the other side to be determined. And issue 1.2, you see from 43.2, are HRD cancer cells, according to the licensed patents, notably found in individuals who have the BRCA1 or BRCA2 gene mutation. And the judge says at 44, this was common ground by the time of the hearing, the parties were agreed that abnormalities in the BRCA1 and BRCA2 proteins are indicators of HRD status, but are not determinative of that status. A cancer in a patient who has BRCA1 and BRCA2 abnormalities is more likely to be HRD. However, that's not guaranteed. BRCA1 and BRCA2 abnormalities can be present, but the cancer can be non-HRD. Equally, patients without BRCA1 and BRCA2 abnormalities can have HRD cancer. Now, against that background, in picking up a point that my Lord Rothschild was making a couple of times this morning about the indications, can I just show you the other side's pleading, which helps to identify where we are with these particular treatments. This is in the core bundle at tab 9. We did open this a little earlier in a different context. Now, I'm going to show you paragraphs 7, 8, and 9. But before I do, can I just make the relevant submission, which is this. There is no pleaded indication before the court where there is no realistic use which can fall within the licensed patent claims. I will make that good by reference to the defence and counterclaim. Paragraph 7, in the US, the FDA, the relevant regulator, as we all know, has approved the use of Zejula, that's the brand name for Narapple, for the following treatments. And then you see what they are. The maintenance treatment of adult patients with advanced epithelial ovarian.
I beg your pardon, I missed the paragraph.
I'm sorry, I'm now reading, I can read it all out, or you can read it to yourself. Yeah. Paragraph 7.
7, yes.
4 bundle 9, page 111. So these are the approvals by the US regulator for Zejula.
So we just read paragraph 7 then?
Yes. And once you've read paragraph 7, I was going to say paragraph 8, but you see what they say in paragraph 8. On their case, which is refuted by the judge, and as you've just seen in his conclusions in 54, in paragraph 56, subparagraph 4, their case was that only the use at 7C, i.e. the BRCA mutation, treatment of adult patients with advanced ovarian, etc., and whose cancer is associated with HRD positive status defined by either a deleterious or suspected deleterious BRCA mutation or genomic instability who have progressed more than 6 months after response to the last platinum-based chemotherapy. They said only that would involve the identification of HRD cells and thus include uses that could possibly be covered or claimed by the US patents. licensed under the license agreements. And that's not, of course, consistent with the judge's findings of fact in paragraph 56 that we've just seen, because the judge says in paragraph 56 that a good response to the platinum treatment, with the possible indication of HRD that came with it, was an example of the medical or scientific procedure involving identification of HRD that was set out in the specification of the licensed patent. And paragraph 9 of the pleading sets out the approvals by the EMA.
So sorry, just make sure. So I should say, first of all, Mr. McLean, I'm almost certainly going to sound vaguely Scottish when I talk to you, because I'm in fact Scottish. So apologies for that.
I'm the last person to expect someone to apologise for sounding Scottish. It sounds good news to me, my lord.
I'm not trying to put on an accent to, just, I'm afraid it just happens. But the point, so that's not why I wanted to say anything. Just I want to make sure I've understood that submission. The point you're making is that in 7B, for example, that is something which has a partial response to platinum.
Yes.
And you say that in the judge's findings that would count, whereas on their case it doesn't.
That's right.
Okay.
That's the point. And therefore, since that applies to 7A and 7B, therefore, there is no pleaded indication where there's no realistic use which can fall within the licensed patent claims.
Would you say these realistic uses all fall?
Exactly. If we take it as double negatives. Exactly. And therefore a license was required, and if a license hadn't been obtained, because there's a potential infringement in all of these uses, potentially the Tesaro would have been at risk of an injunction with all of the or against all uses, once it could be shown that there were some infringing uses, and it's accepted.
So do I understand you correctly? Your submission is that all the authorised uses require a licence.
Yes, that's right. That's right, and that all.
So, in which case, what's the difference between them?
Because on our case, all of the sales of niraparib are potentially infringing.
What do you mean by potentially infringing? Either they're infringing or they're not
Well,
infringing.
no, but that's not right, my lord, because they're only infringing if they are given to a patient with the relevant indication of HRD within the scope of the licensed patent. So in a sense, it's conceptually possible to say, well, they're either infringing or they're not. But it's not possible to determine at the point of sale or within the 60 days when the contract requires the payment of the royalties, whether one's in the category of being infringing or not. And that's why the contract, if it were simply pay to infringe on the basis that Mr. Patton argues on the court, just doesn't work.
Is it? Can I make sure? I'm not sure I understand what you're saying, but I think maybe I do. Is it this, that what you're talking about is if you take a metaphorical box of pills,
yeah,
and you give it to 3 patients, all of whom have the relevant indication. So you think, so that's the authorized indication for the treatment.
yeah.
You give it to 3 patients. One does well. Sadly, the other 2 do not. The argument is that the only case of those 3 which was infringing is in fact the one that did well, because they must have been, in retrospect, they must have been HRD.
Exactly.
Whereas the other 2, who you did treat in the sense of gave them a pill, and it was an authorized treatment,
yeah.
but the argument again you would be that those treatments, because they failed because it wasn't an HRD patient, and the patent is only covers the patients who were in fact HRD, even though you didn't know it at the time you gave them the pill.
Exactly. That's exactly right. That's exactly right. And that leads me helpfully to another point, just picking up on something that I said before the short adjournment, when my Lord Justice Arnold was expressing the view, which is correct, obviously, that there's a difference between the second medical use patents in the European context and the method of treatment patents in the US context. That's obviously right. We don't accept that US patent law presents a simpler set of conundrums. It presents a different set of problems. So, for example, under US law, you wouldn't know if the claims were infringed until they were actually used by a patient. The prescription written by the doctor might not, often would not, specify the use to which it would be put.
It's the doctor who carries out the method of treatment, not the patient.
Yes, and it's conceptually possible, of course, to say, well, the question of infringement is a matter for the doctor, not for the manufacturer or for the pharmaceutical. Conceptually, that's possible.
Yeah, but
But-
you've also got to take into account contributory infringement, because the whole point is that there will be contributory infringement by the supplier of the pharmaceutical.
Yes, of course, but also the manufacturer of the pharmaceutical wouldn't last terribly long in business if it was essentially saying to the doctor, well, you might go on the hook for infringement proceedings here. I mean, that wouldn't be a very sensible way of running one's business. Conceptually, of course, it's possible. So, I think I accepted with too much haste the suggestion that US law was simpler. It wasn't simpler, but it's just differently complicated. One final point before I get back to where I was on the question of small royalty. It is my case that it's a small royalty. And I'll give you two examples of where one gets that from in the evidence. One from
Thank you.
each side, as it were. In the supplementary bundle in tab 5, which is the Dr. Barton email. Sorry, tab 4, which is the one which my own friends rely on. So supplementary bundle, tab 4, page 92. This is the Dr. Barton email we rely on, and the fourth bullet point is small royalty. And the response to that email, which is just above, from Mr. Cook, dear Emma, happy to say our client is happy with the financials, so there's no pushback on small royalty. And then in the same bundle, in the cross-examination of Mr. Mulder, the chief executive of Tesaro, so if you look to tab 14, which begins at page 217, if you go over the page, please, to page 218,
Yep.
and if you just pick it up, please, at using the page number of the transcript is 108, so the one on the top left-hand side. You see it, line 22, question, if I was sitting, this is me, if I was sitting in your shoes in 2012 as a CEO of a business like Tesaro, one of the things I'm most concerned about is to make sure I have the maximum available freedom to operate, the expression you used a couple of minutes ago. That's really what these negotiations are principally concerned with. And then you can see what Mr. Mulder says. I'm not going to read it all out, but you will see that at lines 12 and 13, having mused about questioning the validity of the patents, he then volunteers. We told them that we would no longer pursue the attempt to invalidate what was issued because the royalty burden was not that great, and the University of Sheffield and ICR make important contributions to cancer research and so on. In other words, we saw the small royalty wrap up dealing with all of the sales. That simplifies life and means that all of the complicated questions about what's meant by infringement.
No, I understood that. I understood the relevance of small royalty. I just didn't know where we found it.
Yes, we found it, and so we get it from both sides, and we get it from this. It didn't have to be extracted from Mr. Mulder. He
Thank you.
He copied that. So, can I then deal with the? I'm going to spend a little bit of time in the judge's judgment, not on construction yet, but I'm coming to that, I promise, but on what the judge says about the aim of the transaction, the Lord Wilberforce questions. Now, the judge made findings about all of this. If you take the judgment in the core bundle at tab 5, at page 52, there's a heading in bold and capital letters, findings of fact. And if we skip on over the page to 53, there's a heading of circumstances in which Tesaro entered into the license agreement. And this is, in our submission, much more important in terms of understanding, or much more helpful rather, when one comes to construe the agreements in due course, than one gets from Dr. Barton's email, for example, which is the bit of the factual matrix the other side pluck out and choose to focus on. what the judge says is this, at paragraph 32, both Tesaro and Astrazeneca would have known that the PARP inhibitors such as niraparib had the potential to be used as a monotherapy in the treatment of HRD cancers because of the concept of synthetic lethality that he had described. They would have known that the BRCA1 and BRCA2 proteins were key components in the HR DNA repair pathway. So it follows that both Tesaro and AstraZeneca would have known in 2012 that identifying abnormalities in BRCA1 and BRCA2 proteins was a possible predictor of HRD. Accordingly, PARP inhibitors such as niraparib could be expected to have particular effect as a monotherapy in patients with BRCA1 and BRCA2 abnormalities, not because PARP inhibitors targeted those proteins, but rather because the abnormalities in those proteins were a possible indicator of HRD. And then he picks up some conclusions from Mr. Mulder's evidence, and he finds that in 2012, Tesaro was hoping to use niraparib as a treatment for patients identified as having BRCA1 and BRCA2 abnormalities, who were therefore likely to be HRD, and patients in whom there was no BRCA1 or BRCA2 abnormality, but they were likely to be HRD nonetheless, and even more broadly in patients who hadn't been identified as HRD at all. And then he goes on to explain, and this is, I don't know if it's common ground, but it's certainly in our submission right. The first use 1, was likely to be within the scope of the claims in the licence patents. Use 2 had the potential to infringe the licence patents. That wasn't clear. The belief at the time was that use 2 would infringe only if the patient had been identified by testing as having an HRD cancer. And there was a lot of focus at trial about this concept of testing. But that begs the question of what testing had to be involved. And so you've already seen the conclusion of all of this, because you know where the judge is heading to, because I've shown you paragraph 56, which also will come later. And then paragraph 36, you'll recognise what he says there as essentially picking up the evidence of Mr. Mulder that I've just shown you in the cross-examination. Tesaro briefly considered whether it should challenge the validity of the licence patents, decided not to for a combination of reasons. And you can see what the judge says. He's taken this from Mr. Mulder's evidence. Indeed, if you look at the words of paragraph 36 and that passage of the cross-examination that I've shown you, it's lifted pretty much words for word. You can see the reference at the end to the important contributions to cancer research that were made by the University of Sheffield and ICR. And then he makes the point at 37 that one of the other known unknowns, apart from questions about the scope of the licence patents, is that at the time of the licence agreements, niraparib wasn't proven. It had shown promising results in a phase 1 clinical trial, which is some way away from approval for commercial use in advanced cancer patients. But Tesaro had a long, expensive and uncertain process ahead of it before it could be known whether niraparib could be developed properly as hoped. And so then the judge, using that expression of freedom to operate, but again, Mr. Mulder had volunteered in this cross-examination. Tesaro didn't precisely know how, if at all, it would be seeking to use niraparib. So since it didn't precisely know, it needed a broad license that gave it freedom to operate by developing and marketing niraparib as it saw fit. It didn't need a license that covered all use of all PARP inhibitors, since it's focused on a small set of PARP inhibitors, niraparib and MK2512. And so then he deals with the agreement and how it came about. And it's right that, as Mr. Patton said this morning, shortly before the license agreements were signed, Tesaro obtained copies of the head license agreements. And presumably they read them, and as Lord Justice Arnold pointed out, the very first thing that the license agreement says is it cross-refers to the head license agreements, because that's the, as it were, that's the source of the rights which my clients are sub-licensing. That's obviously right. As it happens, by the time they got the head license agreements, the parties had negotiated and agreed the terms of the license agreements, the sub-licenses, including the one of the changes, or one of the differences between the license agreements on the one hand and the head license is the other is the use of these words may be, which don't appear in the head license agreements, which use they use the word is, as you saw in the definition of part inhibitor in the head licenses. So paragraphs 34 and 35 and 38 of the judgment that I've just shown you are important factual findings because they make clear that whatever other plans Tesaro had for their apparel, it was always contemplated that it would be marketed for a range of uses, which included, but was not necessarily limited to, uses that would fall within the scope of the licence patents.
Well, otherwise, they wouldn't want or need a license.
Right. That's right.
But equally, they were contemplating non-infringing uses. So where does that get us?
That's right. Well, where it gets us is it gets us to the point that they need a license.
That's why they took one.
That's why they took one. They didn't need a license. They didn't need to be licensed to not infringe. Nobody has to be licensed to not infringe.
Right.
But they take a license, and then the question is, what bundle of rights have they obtained under the license? And then what are they going to pay in consideration for it? And one possibility would be that they obtain a license only for that which they need in order not to infringe, whatever that means, and that they would pay only for the uses which did actually infringe, because that's all that they needed. Now, conceptually, that's possible. And now, of course, it suits Tesaro to say, well, that's what we did. But the commercial context and the context of the legal uncertainties about how do you infringe a second-use medical patent, a question which, as one of my friends this morning, I forget which one it was, it said 11 different judges had looked at this question, but just as a matter of English law, and come to a range of different conclusions, including my Lord Justice Arnold at first instance in Warner Lambert, then all the way to the Supreme Court, but we get Lord Sumption and Lord Reid, and we get Lord Mann saying something slightly different but quite close, and then we get two other members of the Supreme Court saying something that was much closer to what my Lord had said at first instance, and so on, as to how one goes about infringing one of these second-use medical patents. So in the commercial uncertainty of infringement, and in the question of how you ever went about finding out as a matter of fact whether any particular use of the pharmaceutical had actually been used in an infringing way, in other words, given to somebody who did have the HRD deficiency. Against that background, did it make any sense to have a pay-to-infringe license, or wasn't it more sensible to have a license which meant that you would pay for all of the uses within those indications which you had sold?
Well, a nice easy way to do that would be to make the payment obligation coextensive with the scope of the marketing authorization, as is not uncommonly done in these situations.
Well, but the scope of the marketing authorization would only answer some of the conceptual legal issues. I see that. But
no, it wouldn't. It would give you a complete answer.
No,
because if you make the payment obligation coextensive with the marketing authorization, then anything that is legally sold will be subject to the royalty.
In effect, that's what the contract does here, because it's got all.
Where does it even refer to the marketing authorization?
Well, it talks about all net sales of the product and the compound. What it doesn't do is anywhere explain how the parties are going to go about ascertaining whether a particular use is infringing or not. It's just left completely at large on the learned friend's case. There's nothing in the contract at all to help to understand how the parties are going to find out which uses attract the royalty and which uses don't. And that's why the other side are forced to have this movable feast of the prevalence of BRCA1 mutations, which changes over time as the science develops, and this movable feast of potentially different tests for what is an infringing use of the same patents across different countries. It's a recipe for continued disputation on a number of fronts.
which is the antithesis of a commercially useful agreement between parties who want to get the freedom to operate and allow themselves to not worry about the intellectual property position of Niraparib. They've got a broad freedom to operate license.
Well, so
with
far
a
as
small
I'm
royalty.
concerned, we're absolutely pushing it an open door when you say that it would have been commercially rational for the parties to agree a royalty mechanism that avoided potential future dispute. And there were a number of possibilities which were plainly on the table. The simplest and most obvious one would be payment for any sale of the compound. Leave it at that. That's straightforward. But of course, Tesaro wouldn't have wanted to pay that much because they didn't need a license that coextensive. A next obvious possibility would make it depend on what was authorised. Of course, at that time, nobody knew what the authorisation would be, but that didn't matter because they couldn't legally sell without the authorisation. As soon as you got the authorisation, everybody would know what the scope was. So that would be a straightforward way of doing it. But instead, the parties chose words which are tied to the patents.
Well, my lord, you're right about the point about compound and stopping there, and Tesaro wouldn't have wanted that. That's correct. And that's one of the points the judge makes in paragraph 133 of the judgment, that the hair loss paragraph. There's another reason why that wouldn't have suited my clients. It's the argument that it might have been said that by doing that, we were conferring a license on Tesaro. It might be read, the last point of paragraph 133, it might result in section 5.3 being read as obliging Tesaro to pay a royalty if it used Niraparib as a hair loss product, which of course wouldn't have been what Astrazeneca was seeking. It's true conceptually, my lord, that one could have a contract by reference to the authorisations in the way that your lordship indicates. But what your lordship's example with respect ignores is the fact that the authorisation was 5 years in the future, in 2012.
But why is that a problem? Because they couldn't legally sell till they got it.
Because they didn't, well, it was in the future. What was going to happen with Niraparib and what shape it was going to take and what it was going to be authorised for and what they were going to use it for were all matters for the day after tomorrow in 2012. The parties made an agreement which must mean something in 2012 and it must mean the same thing thereafter. And what they did on the proper construction of the agreement was simply to agree in 2012 that the royalty would be paid on all the sales, all net sales of the contract, which, of the compound, which maybe within the scope of the licensed patents.
And how does that eliminate uncertainty? That seems to be even more uncertain than the question of whether it's infringing or not on your case.
It exchanges one form of uncertainty for another. What it does, it allows the uncertainty of whether the particular use actually was infringing or not, but gives commercial certainty to the parties as to what's got to be paid and what hasn't got to be paid. And it eliminates, therefore, it doesn't eliminate uncertainty, but it eliminates the aggravating uncertainty that would give rise to the scope for legal dispute, potentially for injunctions, potentially for issues about what infringement meant.
I don't understand how it avoids that. Please explain to me, because you say anything that might possibly, but how do you decide? Is that a 20% chance? Is that enough to make payment payable?
Well, you have to ask yourself in the end whether there are uses that the product's been put which might not fall within the scope of the licensed patent. That's the hair loss example, but that's not where the parties got to. It's not where they anticipated getting to, and it's not where they got to.
Well, hair loss is definitely outside. There's no uncertainty about it.
That's right.
So I repeat my question. Is a 20% chance that a particular use might be held to infringe enough to make the royalty payable?
Well, the concept of 20% chance is a difficult one. Each individual patient is either got the HRD deficiency or they haven't.
Which is why infringement or no is a perfectly rational answer.
In principle, conceptually, it's a yes or no answer. But you don't know which category the particular patient falls into at the time you're making your contract. And you're making a contract which is going to provide for payment to be made in circumstances where you're not only do you not know in advance, you're not going to know ex post either very easily whether a particular patient has or has not got the HRD deficiency. So, as a matter of legal concept, the points your lordship's putting to me are, of course, possible answers.
But
But
what
they're
you
not
haven't
really-
answered is the question I'm asking. So I'll try a third time. Is a 20% chance enough to make the royalty payable?
Yes, it is.
Right. 10%?
Yes,
Right. 5%?
yes,
1%?
yes.
So a 1% chance of infringement is enough to make the royalty payable. And how do you get that out of the language of the contract?
Well, because it's all net sales. It's all net sales.
All net sales of the compound, whatever.
Which but that's not right. That's not right. Let me just pick up the license agreement. It's all net sales. So net sales is the gross amount invoiced for licensed products. Licensed products means a product and combination products, we're not concerned with combination products. Product means any product in a form suitable for human applications that contains the compound as the sole active ingredient. And compound is Tesaro's PARP inhibitor compounds, niraparib and MK2512, the use of which may be claimed or covered by, or the exploitation of which may be claimed or covered by one or more of the licensed patents. That maybe is clearly broader than is, which is the language of the head license, may be claimed or covered by.
So you've already told us that a 1% chance is sufficient. What about 0.1%?
No, my lord, you have the logic of my submission. Why would there be a difference between a 99.9% chance and a 0.1% chance? You have to make the contract.
Commercially rational agreement for anybody to enter in.
Well, you have to ask yourself whether it would be a commercially rational agreement for these parties to enter into in 2012, in circumstances where they didn't know all of these things that they knew they didn't know. How were they going to find out whether a particular use was infringing or not? And if they had intended to have a pay to infringe license in the way that Malone Friends now contend for, wouldn't it have been truly extraordinary not to have explained anything about how the parties were to go about finding out whether the use was infringed? Didn't it say anything about testing? Didn't it say anything about what the proxy would be for whether there should be a certain the testing or the prevalence of the BRCA mutation or what yardstick was going to be used? Well, then our friends now say, oh, well, we can send for an account at the quantification stage. Now, I accept there are contracts in the cases in the books of contracts where the parties have left uncertain some part of their agreement. Sometimes it's said to be an agreement to agree. Now, there are some cases where the parties can have a mechanism in the contract which allows the court to fill in the gaps, the bits that the parties had missed out. If there's some point of reference by which the court can use, some yardsticks by which the court can fill in the gaps. But here, there's absolutely nothing to help the court, the quantification stage, or to help the accountant, or to help the person doing the audit, to work out how the contract contemplates ascertaining which are the infringing uses and which are the non-infringing uses. But that's the whole focus of the contract on Malone Friends case. That's what it's all about. So the contract, the draftsman just forgotten about having anything to help the court to work out how this contract is actually going to work. And that's with respect why my Lord Justice Birss was right, that the same problem applies in spades to the head license agreement, because the head license agreement language is, as it were, tighter. It uses the expression is, not maybe. Now, whatever maybe means, it's clearly broader than is. So these problems about the lack of any mechanism which the judge highlights in our agreements, also apply to the head license agreement.
So you seem to be telling us that your clients don't know what to pay their licensors.
Well, the
It seems quite strange.
well, the evidence is, my lord, on that my clients have been paying under the head license on all net sales.
I don't think my learned friend can mean evidence.
It is evidence. Well, it's common ground.
It's not common ground.
Well, that's what was was before the judge.
Astrazeneca
it's in the pleadings.
choose to overpay a fine. That may be a sensible commercial answer, but there we go.
Well, what it does show, my lord, is that the head license agreement suffers from the same deficiency as the license agreements on my learned friend's construction. And so it also, by the way, is is an answer to the Dr. Barton email, because to the extent that she's saying, or is to be taken on the other side's case, is saying, well, you should look at the head license, and the license agreement falls into line with it. Well, of course, my clients have been paying on all net sales under the head license agreement. So the Barton emails don't get us anywhere at all. So, well, in the end, the court's got to ask itself whether what does one get from maybe in the definition of compound. And in my submission, what's going on is, on the evidence accepted by the judge, Tesaro wanted a broad license, freedom to operate. And one of the reasons that they wanted that was that if they hadn't, well, they needed a license because all of the intended uses of their apparel were potentially infringing.
But is it your submission that they needed or wanted a license that went broader than the patents?
No, they didn't need a license that went broader than the patents. They wanted a broad license, and they were content to pay a small royalty on all net sales rather than have somehow grapple with the, frankly, in some cases, unanswerable issues or impossible to grapple with questions of determining, as a matter of fact, in each individual case, whether the use to which the predicament was put was infringing or not. So they only needed a license as a prophylactic against infringement, but it made sense to have a broad license to give them the freedom to operate without having to worry about possible arguments about infringement, without having to worry about which particular resolution was arrived at in any particular jurisdiction as to what infringing meant, and in order to avoid the potential risk of an injunction, which is, of course, the first and foremost the risk of an injunction is uppermost in the mind of any potential infringer. And as your lordships know better than I, unless the infringer can show positively that sales of the product cannot and will not infringe, there's no carve out from the injunction that's granted when there's a preliminary injunction to show that on the basis that there's a real risk or a serious issue to be tried of infringement. So the broader license with the freedom to operate that Mr. Mulder wanted is a prophylactic against that risk. It takes away legal risk. It takes away commercial uncertainty. And if you're Mr. Mulder, as opposed to a patent lawyer or a judge of a patent court grappling with some of these issues, what you want is commercial certainty, to know that you can get on and run your business. That's what Mr. Mulder was saying, and that's what the judge accepted. And the way to do that was to have a broad license with a small royalty on all the sales. So,
Mr. McLean, can I put this
yes,
to
my
you?
lord.
The point, as I understand the point you're making, you're saying that the reason for what you say is the right construction of the contract relates to some very specific difficulties which arise relating to the specifics of the invention
Yes.
and the patents in this case.
Yes.
It wouldn't arise in many other cases. It arises in the facts of this case.
Yeah.
Is there any indication in the agreement that that clause is there to deal with problems of that sort?
Well, can I think
We can
about
come
that?
back to that.
Think about that. Well, I suppose what one would say is that it's obvious to the parties that these are veterinary medical use patents, method of treatment patents. These are sophisticated pharmaceutical companies, albeit they weren't not now GlaxoSmithKline, who now owns Tesaro, but Astrazeneca and Tesaro were big thrown up pharmaceutical companies who been around these houses before. They understood these issues. They understood the territory they were in.
I mean, just to make sure that you understand where I'm coming from. Part of the point of my question was that this isn't actually because these are second medical use patents, or at least not merely because the specific problems you're talking about don't arise in many second medical use patents. It's because it's a very specific kind of invention, and that's what I'm interested in.
Well, yes. Well, that's why that's what I was getting at in my answer to my Lord Ross versus Arnold, when I accepted that the questions of the authorisation would answer some of the questions, but the particular issues that arise here don't end there.
Mm-hmm.
To pick up your sort example of the one patient who did well and the two who didn't, it's far from clear, certainly within the confines of the 60-day quarterly payment of royalty obligations, that you could ever have a sensible system that worked out whether there was or was not any royalty actually due, if the question is, was that use infringing or not? Those are known unknowables, not just known unknowns, but known unknowables. And that's not a very sensible way for the for parties to draw up a bargain. So, and that's why to say that the question of the mechanism which the judge identified as missing, that we didn't show that there was practice of any such mechanism. So it's not a question of other cases, it's a question of the context of this case and how you make this license work in this particular context. And you can't just say it's a pay to infringe license and somehow leave it there on the basis of, well, we'll work out somehow with nothing in the contract at all to help us what we're going to pay. And what we're going to pay is going to be, it turns out, changing from time to time, perhaps from day to day, as the new scientific papers produced showing us what the prevalence of the BRCA1 mutation is. Is that really what the parties meant? It can't be. So can I then turn to the Barton emails? I deal with this very briefly. It doesn't really matter at this. This is all a bit of a lawyer's construct, the Dr. Barton email. A single email with a lot of weight brought to bear, and a very thin basis for it.
It's two, one for each. I mean, it's a single for each, for sure, but there's two that say the same thing.
Yes, they say the same thing. The judge found is that the point on the Barton emails itself, as opposed to the head license, which is a slightly different point. The point is, the judge found as a fact that the email set out a negotiating position that said nothing about the royalty basis in the head license. And that's a finding of fact, dead against him, and that's really the end of it. He found that there wasn't a common understanding at the date of the agreement that Astrazeneca had a policy not to make a profit on the royalty charge, and again, that's a finding of fact. It turns out that the contract's also so the Barton email itself doesn't take no infringe anywhere at all. If we then come to the head licenses, well, let me just finish off that point because I couldn't take it quite so quickly. If you go to paragraph 72 of the judgment, please. That's the key paragraph on the email itself. I am quite unable to accept that it demonstrates that the parties were transacting on the basis of a common understanding of EZ's policy. Email sets out a negotiating position, and so on. There's no way around that on appeal in this court. The judge then goes on to deal with the head license. Now, the head license could be relevant in conceptually in one of three different ways. The first, which the other side disavow, is that the head licenses and the license agreements are to be construed together because they're back-to-back agreements. Now, they're clearly not back-to-back agreements for at least two reasons. One, they're years apart, and secondly, they're between different parties. And we've put the references to Lord Justice Lewison's textbook. It was in the authorities bundle, but
he's in that passage. He's not addressing a situation where one expressly cross-refers to the other.
well, I'm coming to that. I'm coming to that. So that's the first situation with the contract of back-to-back. The second situation, which is the one that's urged by Mullin and Friends, is that somehow you get into the head license agreements because of factual matrix. But as my lord indicated to Mullin and Friends at the beginning this morning, I think your lordship was having the same difficulty that we were in understanding that, because of course what the head licenses mean is a matter of law, the question of factual matrix, and the other side disavow that they're making any suggestion as to any understanding that these parties had about what the head license meant. So what their case really comes to, of course, if the license agreements that we're principally concerned with mean what they say they mean, they don't need the head licenses because the license agreements are paid to infringe. And off they go. That's their second ground. But rather oddly, they spend a long time in their first ground through this false door of factual matrix to try to get to the head license agreements, because they want to say, look at the head license agreements, those are definitely paid to infringe. Look at the word is in part inhibitor in the definition.
Well, can I be clear where you're going? Because I quite take your point about having problems with this being relied on by way of factual matrix.
It doesn't work.
Particularly in circumstances where, as you rightly point out, is the idea of any common understanding or subjective understanding is disavowed.
Yes.
However, imagine this hypothetical scenario, which is that we conclude that the operative wording in the sublicense agreements is ambiguous, and that we taken on purely on its face. And there is a cross-reference explicitly to the head licenses. Why is it not the case on that hypothesis that the cross-reference to the head license means that that's an admissible part of the language of the agreement for the purposes of resolving that ambiguity?
Well,
Because it's, as you rightly say, it's a question of law. And it's a document that is expressly cross-referred to and indeed presented as being the foundation for the rights sub-license.
it's the foundation of the license rights, because my clients can't sub-license any right that they haven't got a license for from ICR or University of Sheffield. That's completely right. But it doesn't tell you anything useful about the royalty arrangements made in the license agreements for at least two reasons. The first reason is that the language is different. The language is different because the words maybe, which were inserted into the license agreement before Tesaro had seen the head license, as it happens at the behest of Tesaro, which is consistent with Mr. Mulder wanting this freedom to operate, are different from the words in the head license, which are is. There's actually three reasons. The second reason is that even if the language was the same, even if the license agreement was is and not maybe, you would still have the difficulty in persuading oneself that the head license was a pay-to-infringe license in the way that Mullin and Friend contends for all the reasons of absence of mechanism and anything to make it work that I've already explained. And the third reason, I accept that conceptually the court might be able to say, well, we're trying to work out what this license agreement means, and we're having trouble kind of bottoming it out. what tools have we got? What other clues are we given in the material? Well, here's an agreement that's cross-referred. Can't we have a look at that? Of course you can. Yes, of course. But the reason it's there, the reason that reference is there, is because the head license is the font of the rights, or the source of the rights, which are granted under the license. And so that's a separate question from the question of payment. And the reason why you don't get very far when you look at this cross-referred agreement is that the language is different, because you haven't got these words maybe, you've only got the word is. So you've got to ask yourself, well, what are the words maybe doing in the license agreement? Why are they there? What's their purpose? The parties, when they got the head license agreement, which was except before they signed the license agreement, they got the head licenses. They didn't make any changes to the terms of the license agreement.
So what?
Well,
Because suppose
because
that
well,
Tesaro, let's take a hypothetical. Suppose they had some very smart lawyers at Hogan Lovells who thought, we think this will do nicely.
I don't think
But-
they think that's a hypothetical.
But, but they think that there's maybe room for a contrary argument, and they ask for the head license. And when they get the head license, they think, yes, this does confirm it. So we'll now advise our clients that it's safe to sign the sub-license. So the fact that the wording hasn't changed doesn't prove anything, does it?
well, it doesn't prove anything. But the parties, well, there were no changes to the license agreement contended for or sought, if it's relevant or admissible, which it probably isn't, after they got the head license agreement. So you're left then grappling with the conundrum, the hypothetical underlying my lord's proposition is that the court hasn't been able to work out from the factual matrix of the license agreements in 2012. All the material we've been considering is looking at the 2012 position that the parties found themselves in commercially when settling down to make this agreement, plus the language of the license agreements. Is it possible to work out what the contract means from all of that? The hypothesis in your lordship's question is, no, it's not. We're still uncertain. What other material do we go to? What are you uncertain about in my lord's question? Answer, you're uncertain about what the payment provisions are. So when you get back to the license agreement, you're going to find the language is different. So that's not going to help you to resolve the question. The answers to the question, what is the nature of the commercial bargain, is to be found in the language of the 2012 agreement, understood in the context of the commercial situation that the parties were in 2012. And looking back to 2004, when different parties made the head license agreement, isn't going to get you very far. You're also not going to know, or at least not know for sure, you've got the correct construction of the head license agreement, unless you've got the relevant factual matrix that was in the arena in 24 between the ICR and the University of Sheffield on the one hand and my clients on the other, and you haven't got any of that, so you can't be confident that you've got the true construction. You might be able to have a go at it and form a view, but since the language of the critical words, as my learned friend accepted right at the beginning of his submission, when he took you the definition of compound, he told you, and he was right, that the words maybe are critical to this case. And those words are not in the definition in the head license. So
I thought you submitted a few minutes ago that the issue would be the same, even if it said is.
well, on my case, the word is doesn't help them, because you've still got the absence of the mechanism. So is can't mean literally is infringing. It must be more broader than that. That's my submission on the head license, or would be if the sub license said is a better way of putting it. But on any view, the sub license, the license agreement are different from the head license because they use the words maybe. And my learned friend accepted, and he was right, that that's at the crux of the argument. So how could it be, I ask with diffidence and say rhetorically, how could it be that if the court is still struggling to construe the license agreement, if the commercial context of 2012 and the words aren't enough for the court, you're not going to get an answer to your remaining difficulty by looking at the head license by definition, but literally by definition, because the definition there doesn't include the words which my learned friend accepts are critical to the license agreement. So it's not going to help you. So that's why, although I entirely accept that it's legitimate as a potential, as it were, thing to do in construction, to look at cross-reference documents. I entirely accept that. I'm not suggesting you can't look at the head license or any of that sort. I'm not suggesting it's not a part, and in some sense an important part of the background. I accept that. But it's not going to help you to answer the question on this appeal, which, as my learned friend says, critically turns on the effect of these words may be, which aren't in the head license agreement. So that's what I say about the head license in a nutshell. And that's why the learned judge was right in what he said in his judgment at paragraph 73, that the head license agreements were part of the factual matrix. And he then said that it wasn't clearly required a pay to infringe royalty. He said there was a good argument that they might and so on, but it didn't help him to answer the question. And he was, with respect, right about that. So the head licenses, I think I made these points, but there are 4 points about head licenses I want to emphasize. One, we've got exclusive rights under the head licenses to sub-license the license rights to develop and commercialise PARP inhibitors. That's why it's referred to in the first recital. Secondly, we pay the head licensors royalties on all sales of olaparib in countries where royalties are due. That may or may not be relevant to what it means, but that's what in fact's been happening, and Dr. Barton would have known that that was what was happening when she sent her email in 2012.
Didn't exist at the time.
Sorry? Yes, it is. Thirdly, each of AstraZeneca's other sub-licensees under the head license also pay royalties on all their sales in countries where royalties are due. So, where my learned friends say in their skeleton argument on this appeal, at the core bundle tab 13, page 168, no, sorry, there's paragraph 39, that's my next one, sorry, my mistake. Tab before, tab 12, paragraph 39, page 100, sorry, my mistake, page 143, tab 12, page 143. The head license agreements, as will be seen, clearly provide for royalties on a pay-to-infringe basis. AZ and Tesaro knew or can be taken to have known this at the date of the license agreement. Well, that's confounded by the facts in terms of how AstraZeneca has actually been behaving. That might not matter to the construction of them, but that's factually that can't be right. And as we say in our skeleton, this is a reference I just given you, the next tab, tab 30, at page 168. That's the same point. So the true interpretation of the head licenses can't be a question of factual matrix. And I think Lord Justice Arnold and I had agreed about that. And the true interpretation is a matter of law of the head licenses. Well, then Fred Skeleton allied those concepts of construction and factual matrix right, left, and centre, paragraph 5, 39, 50, 51, 1, and I can give lots of other examples. But the real point of the head license is that it's only conceivably relevant if you haven't already got to the answer with the license agreements and the relevant surrounding circumstances. And if you are in that situation and you want to turn to it as a tool to resolve that difficulty, it's not going to help. And I've already made that point. So that's all I need to say about the head license. So then I'm going to come fairly briefly to the judge's construction and why it's right. And can I just ask you please to take up in the supplementary bundle at tab 15 is the closing, these are our closing submissions to the judge. And can I ask you to turn to page 239, please? And you see what we started off by setting out the terms of the contract. And a paragraph, so skipping over the bits of the contract that you've already seen, you see we emphasise in paragraph 35, compound. We emphasise the word, use of which may be claimed or covered by, may be claimed or covered by. And then paragraph 36, our submission was and is that the license agreements properly construed require the defendant to pay royalties on all aggregate net sales of the licensed product, which is not apparent in each country where a licensed patent is enforced. That meets the may be claimed or covered criteria. So that's important. And
Yes,
nothing-
but what we now know is that you say that may be claimed or covered is satisfied if there's a 0.1% chance.
Well, we didn't deal with questions of percentage probabilities before the court. Your Lordship puts these questions to me, and I'm telling you giving our response. But
This is not how the judge has construed it, is it?
the judge, what the judge does is it's not true that what the judge does is something like his own canoe. What the judge
He
does,
construes it as all cancer treatments, but you've disavowed that.
well, that with respect is not reading the judgment in its context. He's not proceeding on the basis that all cancer, all uses, all conceivable uses of niraparib for all conceivable cancers attract a royalty. That's not what the judge is properly to be understood as saying on a fair reading of the judgment. The judge is proceeding on the basis that the factual umbrella under which he's considering these questions is the one that he gives in the first sentence of the last paragraph of the judgment, which is that all of the sales of niraparib are for potential treatments for the HRD cancers. Those are the cancers that we were talking about. So all cancer would be a shorthand for all those cancers. No one was ever suggesting that it was broader than that. And with respect, it would be a misreading of the judgment to proceed otherwise. So what we then went on to say in paragraph 37, and again this is still my submission, is that the defendant's construction was unworkable. And we then explained that the party relying on percentage probabilities and chances as to make the contract work wasn't me, it was the other side. They're the ones who say that they relied on data indicating the average prevalence of BRCA1 and BRCA2 gene mutation was 38% as a proxy for the proportion of sales for a use claimed or covered by the licensed patent. But you see what they're doing there, it's for a use claimed or covered by. They've got rid of those words maybe. You look at what we've quoted in paragraph 39. This is a quote from the other side. What they do, they're relying on this on the 38% as the best available proxy for the proportion of sales for a use claimed or covered by the licensed product. But the parties didn't do that. They had a contract which used the word maybe, which roped in all of the sales of that of the drug within the scope of the licensed patents. And then they changed it again, and so for all the reasons that we went on to say there, it doesn't work. Then we made the point about the injunction at paragraph 45, and then at paragraph 46, we made the point, and this comes back to Lord Justice focus on the particular facts here, and with respect that's right. In the case of second medical use products, the only way to potentially avoid a general injunction would be to apply for what's called the skinny label. But that only works where the indications are clearly divisible and separate from the indication which is said to infringe. And that's the difficulty here on the particular facts, that you couldn't do that. So as we say over the page, there is no scope for a skinny label here. All of the claimant's product is sold under a label which includes an indication for cancers, including those which are known to be infringing uses in the sense of being for HRD cancers. That's the critical point. And so, again, our submission, as you see, was in the next paragraph, may be claimed or covered by, and contrasting that with the other side's construction, which, as my learned friend accepts, would, in order to determine what the license fee is, would require a determination for 26 different countries, construing the claims of the patents under the applicable law, which might differ, analysing the matter of fact for each individual use, whether the act falls within the scope of the licensed patent. And that's commercially, that would be a very strange thing for Mr. Mulder to have committed his organisation to. His shareholders wouldn't thank him for getting involved in such an exercise when it would be simpler to cut through things by agreeing a royalty for the whole box of M&M. So I don't accept that the judge's construction is materially different from the submission that we made. But even if it is, so what? A question of law, and elementarily, in construing a contract, the court's not confined to the way in which the parties plead and argue their respective cases. There's all sorts of examples for that effect. One recent example, just for your lordship's note, my ladyship's note, is the case of Mr. Justice Butcher called Teesside Gas Transportation Limited, where he said the court cannot be limited to the positions taken by the parties. It's open to the court to say the proper construction of the document is not one for which either party is contended. And
To be sure, that's well established. Yeah.
that's obviously right. That's obviously right. So who thought of it doesn't matter, doesn't it, whether it's right.
No, I'm sorry. If I wasn't clear, I apologise. Of course, as you have just completely correctly said, the court is not limited to the constructions adopted by the parties.
No.
However, the question that I was asking was a slightly different one, which is about the forensic posture of a party in the court of appeal. Because it's one thing to support the judge's construction, it's another thing to advance a construction which is different from the judge's construction when you're a respondent. And I'm not, please understand, I'm not trying to raise a procedural obstacle. Technically, if that was what you were doing, technically you need a respondent's notice, but that's not my concern.
I don't want to respond to notice.
My concern is whether in truth your client is supporting the judge's construction, or whether in truth you're advancing a different construction. And at the moment, I think you're advancing a different construction.
Let me deal with that. I'm coming to the judge's construction. And my first point, the next thing I'm going to say is the judge's construction is right and we entirely agree with it. I don't want a respondent's notice. I don't need a respondent's notice. And I don't invite the court to resolve the question of the contract on any basis other than the points we're about to find in the judge's judgment, which I do not accept are a material deviation from the submission I've just shown you. The reason I've taken you to these paragraphs is to show you that what I'm saying now, and what I said in my skeleton, and what the judge says are all pretty much within the same ballpark of analysis. It's true that the judge in the hair loss example says in terms, he says, what is it he says? He uses the word to build on an argument. So he builds on my argument in paragraph 133. And I'm very pleased he did, and I agree with what he said. And his analysis of maybe in our submission is correct in the various respects that he deals with it. And I'm going to deal with it as quickly as I can, take you through the judge's analysis. But I absolutely disavow any suggestion that anything I have done is to disavow agreement to the judge's judgment.
All right.
I'm not
So how do you square your submission with paragraph 132 of the judge's judgment, where he explicitly agrees with Tesaro that the words maybe are not referencing a measure of probability? And of course, you are not even arguing for probability, you are arguing for possibility measured by microscopically small percentages.
Well, what he says, I'm agreeing with what the judge says in the first sentence is that no minimum likelihood is stated as being necessary. That's obviously right. No minimum likelihood is stated. I can't point to one. If I could, I'd have done it by now. It's not there. That's all he's saying. But he goes on in the very next breath to say it's possible to read the word maybe as referencing a different kind of possibility. And then he goes on to explain how it works. Now, your lordship puts to me whether I say that the various percentages you gave me would fall one way or the other in the contract. And the answer has to be yes, they do, or no, they don't. And my answer is that yes, they do. But that's not, I'm not suggesting that there is some minimum likelihood stated in the contract. The judge was wrong in what he says in paragraph 132. What I'm suggesting is that the judge is right in 133 and 134, and indeed in 142, where the judge makes the point, when he comes back to maybe again, for the reasons I've given, Tesaro did not actually need a license that extended beyond the claims made in the licensed patents. That's correct, I agree. However, freedom to operate was an important issue for Tesaro at the time. Therefore, I'm prepared to accept that the definition of compound was expressed by reference to uses that may be claimed or covered, rather than uses that actually were claimed or covered, to emphasise the width of the licence that was granted. And then he explains that that was the judge's now a slightly curious place to put it, to deal with it, and it might have been done in a different way, and your lordship's given examples of other ways in which a more felicitous drafting could have been obtained. And of course, every advocate can always say in any case that the parties could have done this, or could have done that, or could have done it a different way. But the judge is right there as well. And the judge is right in both the reasons he gives at paragraph 133, that the definition of compound, stopping after identifying their apparent, wouldn't have worked. It wouldn't have suited either party for the reasons the judge gives. It wouldn't have suited them because they might have been obliged to pay a royalty on the hair loss example. So all that the judge is saying is there isn't a minimum likelihood stated in the contract, but how is one to make the contract work? And in fact, as it turns out, we haven't got Zejula and Nirapara being used for hair loss or ingrowing toenails or any other obvious use miles away from the licensed patents. Indeed, we've only got it being used in the authorizations which I showed you in the pleading, the platinum deficiency and the BRCA1 and BRCA2 mutations. But the critical point is that we've got it being used in a way which we don't know, we can't see, nobody can see whether the particular use is infringing or not. And the question is, what does this contract clearly contemplates a royalty being paid. What happens in that situation? Is nothing paid because we can't show any uses infringing? Is a royalty paid on all the net uses because they all may be covered by the licensed patent? Yes, that's my case. Or is there some other mechanism that can be whistled up somehow to make the contract work without any visible means of legal support, which seems to be my own friend's argument, will be done by some accountant in due course. So, look, the judge's judgment, let me just take you through what I say are the critical paragraphs. I know you've read the judgment, so I'll just identify these paragraphs if I may. Starting at 116. The judge recognises, makes the point in 116, last sentence, Astrazeneca has no power to grant licenses that permitted Tesaro to exploit niraparib in ways that might infringe any other patent. So that's obviously right. 117, fourth line, only net sales of licensed products count towards the calculation of the royalty. When the definitions set out in paragraph 112 are put together, it can be seen that the question of whether a sale of a particular product is to count for royalty purposes is determined by asking whether that product contains the compound as the sole active ingredient. So that phrasing suggests an analysis of whether one physical substance is present in another, rather than a consideration of the use to which the products are put, is to drive the calculation of royalty. Then we get to compound. He sets out the definition. And then Tesaro's case last sentence, only uses that would otherwise infringe a licensed patent would be caught. So the royalty should be calculated on the infringement basis. Then he identifies the two difficulties, and those two difficulties are the two difficulties. And the second difficulty, in particular, is one to which there is no answer advanced. All that we're told by my learned friends is that, well, we don't need such a mechanism. Pay to infringe is the norm. There's no basis for anything. There's no need for anything else in the contract. But there absolutely is. Otherwise, a contract that doesn't work. And the judge elaborates on that second difficulty. And I just want to show you these paragraphs. 123. First of all, he deals with the future point. And then he says, I consider the second objection is a real force. This is 1, 2, 3. As well as giving rise to the difficulties with calculation I've highlighted, Tesaro's interpretation would mean that ascertaining the amount of royalty payable would depend on a continuous review of the scope of claims under the licensed patents in 26 different countries. Now that's important. What the judge is saying is, it's not just a question of the pound, shillings and pence of it. What the contract actually substantively provides is shifting on the other side's case. Its substantive content is moving. And that's a curious thing for a party to agree that wants freedom to operate. And then he makes the points at 126 and 127 that the way in which Tesaro has actually paid the royalties is antithetical to their own construction now advanced. And he says on 127, the license agreements required Tesaro to provide periodic written reports to Astrazeneca, showing, among other matters, net sales of the licensed product. In its report for the fourth quarter of 2017, Tesaro took the position that, calculated by reference to the average prevalence of the BRCA1 and BRCA2 gene mutation worldwide. That approach caused it to calculate the royalty was payable only in respect to 38% of sales. There is nothing in the license agreement that supports that approach, and there isn't. The licensed patents cover the use of a PARP inhibitor in a patient whose cancer has previously been identified as HRD. While BRCA1 and BRCA2 abnormalities are possible indicators of HRD cancer, they're not synonymous with HRD status. So their own approach is antithetical, and that's obviously right. And as the judge then goes on to acknowledge, that doesn't show, doesn't prove that they're wrong about construction, but it's a pretty bad start when the party that's contending for the pay to infringe royalty position is quite unable to come up in the, 12 years since the contract was drawn up, any mechanism which actually accords with the construction that they're now contending for. So I do emphasise, and I've touched on this, but I do emphasise and rely on the fact that these parties would have known in 2012 that the question of how one infringes a second-use medical patent was far from clear in 2012. It may not be much, but it's a bit clearer now. Certainly was far from clear. So if the parties were setting out to agree a license, and if they were going down the road of a pay-to-infringe license, they'd have said to themselves, well, hang on a minute, these are second-use medical patents. What constitutes infringement? It's quite separate from the question of whether we can actually demonstrate that once we know what infringement means, there's actually been infringement. What does it actually mean? And I'm not going to weary those of us who aren't so familiar with the case, or those who have been involved in Warner Lambert, by going through all of it. But Lord Justice Arnold grappled at first instance with that question in a case reported back in 2015.
Yeah, can you help me on this? Because I was reminded by Mr. Mitchison, of course, that was, and as you just said, this was well after the days of these sub-licenses.
Yes.
So is that admissible as an aid to construction?
Well, what's admissible is that,
because I think many of the difficulties that emerged during the course of the Warner Lambert case came as a bit of a surprise, even to those of us who thought we knew a bit about patents.
Well,
Well, hold on. What I would say is this. Your lordship, in your judgment about the subjective intention and when your lordship refused the injunction, your lordship explained that, really set out for the first time, what the test was for infringement of the second use medical patent. And your lordship, I think, says, we can look at the judgment if necessary, that you explained that that was an issue of some controversy. What we then see as the case went up eventually to the Supreme Court.
Yeah, well, that was, I think you're referring to the interim injunction
Yes, I am.
judgment. And of course, it then went to the Court of Appeal,
Yes.
and then it came back to me
Yes.
on trial, and then it went to the Court of Appeal again, and then to the Supreme Court. So by the time we got to the Supreme Court, matters have moved on quite a way from what was said at the time
That's
of
right.
the interim injunction judgment.
That's right. And when
But
we
none
get
of
to
this is admissible, is it?
well,
Because this is all well after the date of the sub-license agreement.
it's relevant in this way. These were very sophisticated, some of the biggest pharmaceutical companies in the world in 2012. When they are settling down to reach an agreement wanting freedom to operate, one of the part and parcel of that is freedom to get on with running their business without scope for unnecessary legal dispute.
Sure, but they get that by getting a license to the patents, and there's no dispute that they've got a license that covers everything that might infringe. The question is, what do they pay for that?
Well, there are two questions with respect. That's part of it. But that in itself doesn't tell us what they're paying for that right. And secondly, it doesn't grapple with the particular question that arises here in the particular context of this particular cancer. That even when you've got the license, and even when you know what the authorization is, and there's no dispute about any of that, and even if we know unambiguously what's required to infringe this second use medical patent, we know in 2012, we know that we're not going to know whether any particular use is infringing or not. We know that. And your lordship's point is no answer to that. No answer to that known unknown. And that's why, my submission, the parties used the language that they did, which was broader than is, of maybe, with the result that, provided the use was being, the treatment was being deployed for a use which might turn out to be infringing. In other words, would be given to somebody who might have HRD deficiency, a royalty would be paid. That dealt with all of these difficulties. And your lordship's analysis of the legal position is, of course, correct as far as it goes, but it doesn't give the freedom to operate that Mr. Mulder wanted. And if you've got your lordship's hypothetical legal advice saying it's all right, old boy, don't worry, once you've got the license and we know what the authorization is, everything will be fine. Mr. Mulder would have said, well, how do we know whether the actual tablet's been given to somebody who had HRD or not? How are we going to show that?
I'm sorry if I'm repeating myself, but I'm struggling to understand the relevance of this freedom to operate argument, because you get freedom to operate by getting a license under the patents. That, it is common ground, Tesaro got. So they got complete freedom to operate. There was never any question of any infringement or any injunction so far as Tesaro was concerned. That was the whole point of taking the license. But that doesn't answer the question, what's the royalty payable?
No, but you say, your lordship says, well, they had freedom to operate because they had a license that meant they had a license which protected them from infringement. That's correct as far as it goes, but it doesn't help them if there are difficulties and uncertainties and grey blurred lines about what's actually meant by infringement of these patents. And it doesn't answer the question of how you go about showing that any particular use is or is not infringing.
I fully accept the difficulties of ascertaining infringement, but they are protected whenever they do infringe. And the question is, do they have to pay for the non-infringing uses? That's the issue.
Well, look, I don't accept that freedom to operate is to be understood in the narrow legal sense that your lordship's putting to me. I understand the point your lordship puts,
but it's not, it's not the sense of freedom to operate that the CEO of Tesaro would have understood as being a full answer to his desire to have commercial freedom to get on with running his business without having to worry about legal disputes. And he was willing to pay the small royalty for the whole box of M&Ms rather than have to worry about the green and yellow ones in circumstances where there was only a patent for the red ones. That's what he was saying, and that's what the judge was saying, and that's why the judge construed this contract in the way that he did, in a way that where there are these two possible constructions, makes the contract work in a sensible way without leaving much to being somehow resolved later, quantification, without any visible means of supporting the contract, which is a commercial nonsense. So, Lord, you know what Warner Lambert said, and Lord Briggs, in fact, said in Warner Lambert, he said, "I've not carried out my own intense review of the European authorities, because counsel didn't suggest that either the summary of them or the conclusion they provided, or the conclusion that they provided no clear answer, as set out by Lord Justice Floyd, was wrong. There appears to be a spectrum of differing approaches to the question of the relevant mental element built into a purpose limitation in the process claim. It may well be that the courts in different contracting states reach solutions which differ because of the particular aspects of their national law and infringement and the structure of the relevant markets, mean that striking a fair balance between protection of patentees and legal certainty for the lawful activities of third parties produces a different result in each jurisdiction. That may be unfortunate, since the construction of claims in a European patent ought to be consistent across all contracting states, but there is nothing which this court can do about it, save to proceed with due regard to the decision of those states' courts." Now, in my submission, that's exactly the sort of unfortunate position that Mr. Mulder would want to avoid. He would want not to get into that legal quicksand in 26 different countries or even one country. That's why he made an agreement which meant that a small royalty would be paid on all sales. So I don't accept that the judge went beyond what I was submitting. The words "maybe" are important, as my learned friend said. They're clearly wider than "is," and they capture the situation where at the point of sale, a particular packet of capsules could be expected to be put to a use falling within the scope of the licensed patents, even if ultimately it's not. But ask yourself this question: where at the point of sale there's no realistic prospect of the packet being put to a use falling within the scope of the licensed patents, then it's out of scope and there's no royalty payable. That might be because it's a hair loss example, or perhaps in a jurisdiction where the claims of the licensed patents are limited such that nirapara isn't covered, or some jurisdiction where there is no patent at all. But without the maybe license, without the maybe language rather, the license agreements would provide that as long as there are licensed patents in force in a country, notwithstanding that the scope of those patents didn't cover nirapara, sales of nirapara would attract a royalty. That's why they have a purpose. It's not right that, as my friend submitted, the courts will strain not to construe a contract in a way that gives no effect to words the parties have used. Of course, that's right, I accept that. And if the words "maybe" were entirely redundant or we couldn't make any sense of them, there might be some traction in what he was saying. But there is a purpose to the words "maybe," as the judge explains in paragraph 133, part of which helps them, part of which helps us, which explains why it was mutually convenient for the parties to reach the bargain that they did. So, in circumstances where Astrazeneca has got the benefit of a licensed patent in a particular country that could never cover the use of niraparib, for instance, because a patent is limited to a completely different type of PARP inhibitor, the maybe language tells you that sales of niraparib in that country would not attract a royalty. They would be, to use my Lord's percentage example, a 0.0 chance of that being covered, because sales or use of niraparib in that country can never be said to infringe the patent. So the judge gave proper meaning to the words "maybe," which are the key words which explain why this is this is clearly a contract, more clearly even than the head license, an agreement which provides for royalties on all net sales. And Astrazeneca was quite wrong to suggest to the judge, sorry, Tesaro was quite wrong to suggest to the judge that Astrazeneca's argument interpreted the definition of compound as if it referred only to a physical substance and therefore gave no effect to use in the definition. That was their submission, and the judge rejected that in paragraph 130. And that's all consistent in my submission with the last sentence of 122. Your Lordship took me to 132 and 133. I dealt with 133 and I've dealt with 142. And the judge also dealt with maybe at 122 because Tesaro's suggestion was that these were merely words looking to the future. And the judge said at the end of 122, the more natural reading of maybe is as referring to the extent of the use that is claimed by or covered by the licensed patents.
So is that not precisely why the judge has construed it as covering all cancer uses but not hair loss?
No. He hasn't. I've made my submission about all cancer.
He says extent of use. He doesn't say the percentage chance.
No, he doesn't.
On the contrary, he rejects the percentage chance analysis.
Yes.
So that's why he says it's for all cancer, doesn't it?
Well, he doesn't mean. I said facetiously this morning, cancer debate. He doesn't mean all cancers. He means the HRD cancers for which Zidula had authorization because they were all potentially infringing uses. And the reason he's fortified in his conclusion, just finally on the judge's instruction, having looked at the words of the contract, he concludes at paragraph 136 that our interpretation was much the better, having regard to the words of the agreement. It wasn't without difficulty. It wasn't entirely a straight line construction because of what he says at 134 and 135, but much the better, and the judge was right about that. And then he went on to ask himself about the inferences from the factual matrix. And he says at 137, end of the first line, I found that both parties would have been aware that in 2012 there were uses of niraparib as a cancer treatment that did not fall within the scope of the claims in the licensed patent. So this is why my Lord Disrespect's not right to say that he thinks it's all cancer treatment. He clearly doesn't. He clearly understands what the licensed patents say, and here he's dealing with it. The way in which Tesaro would actually use niraparib is not fixed in 2012. However, I have concluded that Tesaro had in mind the possibility of using niraparib in ways that would not infringe the licensed patents. And then he deals with the chump and the royalties point. So it's clear beyond argument, my Lord, that the judge accepts that both parties were aware that there were uses of niraparib as a cancer treatment, not just hair loss, as a cancer treatment that did not fall within the scope of the claims in licensed patents. And then he deals with Tesaro's argument, which is the Mr. Hoxie's chump point. Mr. Hoxie said nobody wants to be a chump and pay royalties for nothing. And of course, Tesaro latched onto that. And the judge said, I'm unable to accept the argument precisely because its plans for Zidula were uncertain. So it's not just the commercial freedom and the certainty of having a license. Its plans were uncertain. What it was going to do was uncertain. The scope of the license patents wasn't certain. They sought and obtained a broad license that would permit it to use niraparib in any of the multiple ways whose use might be claimed in the license patents. So there he's dealing with claims within the license patents. In the previous paragraph, he's contemplating treatment for cancer that didn't fall within the scope. And there's nothing commercially irrational. It meant they would have the necessary freedom to operate to permit it to exploit niraparib as it saw fit, even if ultimately it didn't exploit niraparib in all the ways whose use was claimed in the license patent. No more commercially irrational to behave in this way than it was to pay a royalty, even though it entertained some doubt about the validity of the underlying patents. That's the point Mr. Mulder had made in the answer to the cross-examination point that I showed you just after the George John. The broad license brought with it commercial certainty. Having obtained a broad license, there was a question as to how royalties should be calculated. If there had been a clear dividing line between uses of niraparib that would infringe rights under the licensed patents and uses that would not, it may well have been possible for AZ and Tesaro to agree a basis of charging royalties by reference only to infringing use. This is my Lord Justice Birss's point, that we have to look at the particular facts here. However, both parties would have been aware that the licensed patents were second-use medical patents. Well, your logic, well, some of them were anyway, and the US ones obviously weren't, but some of them were. The boundary between infringing and non-infringing use was uncertain, not just because of the terms of the patents, but also because the question of whether use was potentially infringing or not might well depend on what took place in a doctor's consulting room on the particular characteristics of a patient who had been presented to jurors. Nothing commercially irrational about agreeing a royalty based on total sales, which sidestepped all of the difficulties that would have been associated with a royalty charge on a pay to infringe.
That seems to be saying it's the compound per se.
What he's saying is, well, he's not saying that, no. We know he's not saying that because he's explained in paragraph 133 that the definition of compound couldn't stop at the reference to the product for the reasons he gives. What he's doing is asking himself whether, as Tesaro contended, it didn't make any sense for them to have agreed to pay on all of the sales, but only the infringing ones. And for all the reasons the judge gives, he's suggesting that isn't how the contract's properly to be construed. So what's wrong with the judge's analysis? My answer is nothing. Not as a matter of the construction of the words of the contract, and he's clearly right in his the support he derives from on these factual matrix points. And for good measure, he then goes on to deal with freedom of operate. Paragraph 141. If Tesaro's argument is correct, first line, then the license agreement only gave it a license to exploit their apparel in ways that would otherwise infringe a license patent. However, Tesaro did not need any license broader than this. And again, that's true conceptually. To the extent its use actually infringed, Tesaro could rely on its license. That's the point your logic has been putting to me. To the extent its use did not actually infringe the license patents, Tesaro did not need a license. That's, again, your logic saying, well, they've got the freedom. Therefore, I do not accept that Tesaro's interpretation of the license scheme would deprive it of the freedom to operate as it needed. We're not with a license under the possibly invalid precedent, nor that, etc. They never needed a license to use another power in ways that were not within the scope of the claims. And then he accepts that they didn't need the license. However, freedom to operate was an important issue. And then he goes on to make the same point again. So there are just a couple of three other points I want to make, and then draw the threads very briefly together. 2 points on the other terms of the license agreement that we haven't touched on so far. If you take the Sheffield license agreement, please, at tab 8 of the supplementary bundle, the one that we've been using, the other one's material is the same. If you look at the definition of net sales again, just very briefly, at page 119, paragraph 134, Mr. Patton referred to this earlier. Can I just ask you to look at the end of it? Page 120. After 134.6, any of the deductions listed above that involve the payment by Tesaro or its affiliates shall be taken as a deduction in the calendar quarter in which the payment is incurred by such entity. For the purposes of calculating the net sales of bundled products, deduction shall be apportioned across all products in the bundle on a fair and reasonable basis, provided the percentage rebate or discount apportioned to the licensed product shall not exceed the percentage rebate or discount applied in total to the bundled products. So bundled products, your Lordship and the lady will know, are where separate products are sold to a single customer as part of an aggregated offering. Bundling of TV, telephone, whatever, lots of bundled products. If Tesaro was right about net sales only covering infringing uses, it would have been quite straightforward, would it not, for the contract to have covered apportionment on the same or similar term. In other words, extend bundled products to include where the same product was sold to a single customer in the expectation that it would put to infringing and non-infringing uses. In other words, we can see that the draftsman of the contract understands how to deal with things which are bundled together. And if Miller and Friends construction is right, it's a bit odd that we haven't got something similar dealing with the payment mechanism, and it doesn't do that, of course, which is a point, that's a point in my favour. And finally, on the contract at 5.7, my own friend took you to 5.6 and then curiously to 5.8, but he didn't go to 5.7. And the reason he didn't go to 5.7 is that royalties are calculated quarterly and paid within 60 days of the end of the quarter. And if Tesaro is right in its interpretation, it would be required to be in a position within 60 days at the end of each quarter to report on whether each individual unit of product sold during the quarter was or was not put in infringing use. And on the face of it. And because there's no mechanism, no reference here to some other proxy mechanism. That's all it says. And again, that's not consistent with Mother and Friend's construction. It's very likely that not all the product will have been dispensed within 60 days. Wouldn't have been used at all. They may have, as we explored with Mother and Friend, they're not putting the pill down anybody's throat. They're simply selling the medicaments.
Yeah, but you don't have to be the doctor to infringe these sorts of patents, as we were discussing. That was the whole point of the Warder-Lambert litigation, was it was all about the liability of the supplier of the product.
Yes, it was. Well, anyway, that's another pointer we say to our solution. Finally, the point about the license being too broad. This has always been a non-point. Well, then, friend, took you to paragraph 44 of our skeleton, which is in the core bundle at the last paragraph 13. We took you to paragraph 44 and 45, and he asked you to read it, and I waited with bated breath for what was wrong with it. Your Lordship looks puzzled. Tab 13, our skeleton argument, which my then friend Mr. Patton took you to this morning, in the core bundle, tab 13. And he asked you to read, and you did, paragraphs 44 and 45. And I waited with bated breath for my then friend to tell your Lordship and your Ladyship what was wrong with it. And he didn't. He more or less, he accepted it, I think. And in my estimation, what we say is correct, that there is the freedom to operate is conferred by the license, which removes the risk that Mr. Mulder was concerned about. The royalty provision is the mechanism by which they pay for the benefit of removing the risk. And so the fact that they are paying for something which they don't need conceptually a license to do is true. There's nothing wrong with that. And indeed, in this case, it makes all commercial sense for all the reasons the judge gives and all the reasons I've been banging on about this afternoon. Makes perfect sense. But there's conceptually nothing wrong with a royalty mechanism which means that a party is paying money to do something that it doesn't need a license
You're
to
plainly
do.
right about that, because it's not uncommon for
Absolutely.
patent licenses to contain royalty provisions that are not tied to the scope of the license.
Yes.
So I gave an example earlier, which is use of the marketing authorization. But the point that Mr. Patton made is that that's not how this license is drafted, where the royalty obligation is coextensive with the license. That was his point.
Well, but he's wrong about that. But
Right. Okay.
that's the argument.
That's the argument.
No, that's
exactly.
the argument. That's the argument. But it doesn't help him to complain that there's something as about odd about being required to pay for something you don't need a license for. It's not in the territory of there being something unlawful about that.
You say that, but what about patent misuse?
Well, patent misuse was never was never a runner in this case. Well, let me deal with it.
Accepted it was a factor in favour of Tesaro's interpretation.
Well, yes, he did. But what he said, there was evidence from distinguished retired U.S. patent judge and from a distinguished practitioner of U.S. patent law on our side, and there was lots of debate about a case called Zenith and a case called Automatic Radio. It's all in the judgment. I can take your logic to it if necessary. But the long and the short of it was that unless you could show what they called conditioning, as the judge says, coercing or bullying or strong arming, unless you could show that, there would be no conditioning, and if there was no conditioning, there would be no patent misuse. And in circumstances where it was the other side who had suggested the payment mechanism, it was always very difficult to see where US patent misuse was going. And as the judge says in paragraph 82, and I mean, this really is, I mean, one can hear one could hear, try to hear the words, hear the sound of the barrel being scraped when we got to this point. 82.5, there will not be any conditioning if a total sales royalty is the mutual convenience of both patentee and licensee. And that's what happened here. That was the position. That's what happened on the facts. And when you looked at the exchanges between Emma Barton and the other side, there was no hint of any conditioning. There never was any hint of any conditioning. So although it's true that the judge contemplates that there was some prospect that there might be some question of patent misuse, which he says at 146, some indication that either the party would not have wished to agree a total sales royalty because of the risk of patent misuse, or if they had, they would have stated expressing the contract was agreed for reasons of mutual convenience. He gives it some weight. But the idea that that carried any sufficient weight to overcome all the other points is really with respect for the Birds, because there was no evidence of this provision having been the result of any coercion or strong arming or conditioning on my client's part, and it was always a fairly desperate point.
So as I understand it, your submission is you support the judge's approach, you accept that it's a consideration of, quotes, some weight, but you support the judge's approach that it's not sufficient to displace the construction that one arrives at from the language of the agreement.
What I would submit is that the judge's conclusion in 146 is, if anything, rather charitable on the evidence. The position actually was that.
Do you have a respondent's notice on that?
No, I don't know, because it doesn't really matter. I'm happy to take what the judge says as being some indication. He says it gives some weight. He doesn't say how much. He just says it's not sufficient to displace the inferences drawn, not so obviously high. It'd be contrary to common sense for the parties to be a total sales royalty. And the idea that I would put in a respondent's notice on that is I'm not sure most constitutions of this court would have welcomed that, and I think that would be not necessary. Patent misuse is a bit part player, and to the extent it has a speaking role, it's only got the odd word en passant in this drama, and it doesn't go much further than that. Can I just check that there isn't a long list of points that I should have made? I hope not. Yes, just 2 points. I think in the other side of the skeleton say that the word, they say maybe, let me just find what they say. They say that maybe, yes, this is it. In the other side skeleton at paragraph 74, tab 12, page 151. So let's just to give you your bearings. If you just look at the previous paragraph 73, as well already noted, the judge thought that the words "maybe" created a difficulty for Tesaro's construction. Wrong to do so, Broom and Bachelor. And then next paragraph, the use of prospective language is natural for two reasons. First, some of the licensed patents had not yet been granted. It was inherently uncertain whether they would ever be granted, and if so, of what scope. The words "maybe" reflected this. The judge rejected this explanation, holding the phraseology "is" or "maybe" could have been expected to cater for this. However, while a more precise or elaborate draftsman might have opted for that phraseology, the expression maybe necessarily encompasses is. Well, I'm not sure about that, but what's definitely right, as I've already submitted, is that maybe is clearly broader than it is, and that's why ultimately the head licenses don't help. But both certainly contemplate a product where at least some of its uses will infringe. And then finally, I made a bad point, which I want to withdraw and correct in my enthusiasm for Dr. Barton's email, when I said she would have been aware when she wrote that email about the basis in which Astrazeneca was paying under the head license. That was a bad point, which I withdraw. The reason it's a bad point was that AstraZeneca's Olaparib product was first approved in 2014. So in 2012, the Barton email couldn't have known about that. So that was a bad point, for which I apologise and I withdraw, and I never said it.
Thank you for correcting
Unless I can help the court any further, those are my suggestions.
Anything else, Richard? Thank you very much indeed. Yes, Mr. Patton.
I'll start with an absolutely fundamental question for the court on this appeal. What construction of the sublicenses is AstraZeneca actually putting forward, contending for on the appeal? It was a question that my Lord, or Justice Arnold, asked at the outset and on a number of further occasions, and with respect rightly, because it's fundamental. And we would respectfully submit that you never got a clear answer. And the absence of a clear answer is itself a point against them, because commercial parties would have expected the meaning of the contract to be capable of being answered clearly. And if that is problematic to articulate, that suggests that what is being argued is incorrect. As my Lord said, there isn't a respondent's notice, and so one would have assumed, certainly based on the skeleton, that they were seeking to uphold the judge. But as best we understood my learned friend's submissions, that is not actually the construction he is contending for, because the construction he put forward is whether there is potentially an infringement. Now, that is the argument they ran at the trial, and as my Lord has pointed out, the judge specifically rejected, and there was no attempt to revive it until today. But since I haven't addressed that construction hitherto, we say the judge was obviously right to reject that construction, and that's for a number of reasons. First of all, that puts paid to the argument that's made against us. Well, your construction requires you to consider the patent claims in 26 different countries, because on their approach, you would also have to do that, but instead of asking what is the actual scope of the claims in the 26 countries, you'd have to ask a different question. What's the potential scope of those claims? Which is a difficult and more confusing question. Second of all, the test of a potential infringement of the claims is ill-defined and uncertain, and therefore it's not something that commercial parties would have been likely to have intended. When my Lord pressed my learned friend, he ended up taking the position that even a microscopically small chance of an infringement was sufficient. And we would suggest that simply makes no sense of the contractual language. You would have been much better off simply striking through those important words in the definition of compound, because actually they're, if anything, misleading and confusing on that approach. That's what he said. Anything other than a 0% chance of infringement is caught. Now when my Lord challenged my learned friend about that submission, he said that this was a point that had been raised for the first time in the course of this appeal, and he was seeking to answer your Lordship's questions. But just so you know, it's not a new point. We made precisely the same point in our closing at the trial last year, and it may not be necessary to go to it, but it's in the supplemental bundle, tab 16, page 302, paragraph 145. And what we said was, what was never explained is the contractual text to which AZ now contends. AZ appears to say that if there's no possibility at all of an infringing act, the maybe test is not met, but it advances no positive case as to what degree of possibility is sufficient. That's fundamentally uncertain. No guidance is given as to how remote, realistic, or likely the possibility must be. So this is a point that's always been on the table, and AstraZeneca has had many months to think about what the correct answer is, and the answer that is given today is the only answer we've ever been given.
Just remind me which bit of the judgment you referred to a minute ago, where the judge rejected the point.
Yes, I think it's 132. So that's page 77 in core bundle tab 5. It says, I agree with the words, I'm not referencing a pure measurement of probability since no minimum likelihood is stated as being necessary. Yeah. Now, the third difficulty with this argument is that while my learned friend has sought to apply the test in the context of royalties, the point about the contractual architecture means this must also be the test for what license has AstraZeneca granted Tesaro. And so their answer is, AstraZeneca has granted a license for potential infringements, not just actual infringements, and that's obviously uncertain. But in fact, as my learned friend developed it, they have granted a license for any use which has a more than microscopic chance of being an infringement. So that must mean that they are granting a use for many things that are not actually an infringement, they just have a more than 0% chance of being an infringement. It's a license for something that might be a 0.1% chance of an infringement. Now, the obvious answer to that is AstraZeneca has no power to license anyone to do something which may merely have a 0.1% chance of being an infringement. Didn't have the right to do that under the head licenses, and it therefore could not grant that right to Tesaro. Now, we therefore say the judge was right to reject that construction. Now, at other times in his submissions, my learned friend said he was seeking to uphold the judge's construction, but we would suggest that he did not grapple head-on with the criticisms that I made in my submissions of the judge's reasoning, and I won't go over them again. But in particular, there is no sensible answer to the question that my lord put a number of times, that the only license, and only a license under the patents, that was the only license that could be granted and that was needed. There's no answer to that. There's no answer to how do you get from the contractual language to the judge's reference to cancer treatment. That simply isn't possible as a matter of interpretation. And there's no attempt to deal with the contractual architecture point. My learned friend took you to the paragraphs in his skeleton, but what he didn't explain is how can you have a license for one thing, a royalty based on something different, when they both use the exact same definition, compound, to delineate their scope. Now, so far as the approach is concerned, I don't disagree. I agree with all of the propositions that my learned friend wanted to tell you about at the start of his submissions, the general principles of contractual construction. But we would suggest that it's quite telling that the way in which he then presented the argument is by starting with what he said would be commercially sensible and then reasoning back from that point. And none of the principles that he took you to suggested that that was a legitimate way to construe the contract. On the contrary, they say that is exactly the wrong approach. You don't start by positing this would have been sensible to agree and then seek to retrofit that into the contract. Now, one of the 5 points of principle was that you construe the contract as a whole. Obviously, we agree. And that was why I specifically emphasized clause 5.5, which is another indicator in the contract as to what is being intended. And my learned friend did not explain, we say, why 5.5 would have been expressed in the way that it is, specifically by reference to what is covered or claimed by the licensed patents, if the royalties are then being calculated on some completely different basis. Now, my learned friend sought to adopt in that connection a point that my Lord Justice Birss had put to me in relation to the use of which may be language. And the first point your lordship put to me was that if it had said is rather than may, that would be no different. And my learned friend purported to adopt that point as a point in his favour. And I say, well, that cannot be a point in his favour, given that he is actually interpreting this to mean potential infringement. Obviously, is would not be the language of a potential infringement. And that's really the point that my Lord Justice Arnold made, that once he accepts that it makes no difference whether it's may or is, there's actually no difference between the parties. We both agree that it's an infringement-based license and royalty, and then there's a question of quantum, which is for a later date. And I make the further point that if, as my lord put to me, the tailpiece of the definition had said is, you would essentially then have the same language as we see in clause 5.5. Clause 5.5 says that covers or claims. On your lordship's example, the definition says is claimed or covered by. Those are essentially interchangeable expressions. Now, when we have those words in clause 5.5, it's common ground that they do real work, because they tell you when does the royalty start and when does it end, and you do actually have to look and see, does the product that is being sold fall within the scope of the licensed patents? And if it does, then the royalty obligation starts, and if it doesn't, then it stops. And since that may be a difficult judgment in certain circumstances, that's true. But clause 5.5 undoubtedly requires you to do that, because that's the test of coverage. And we would suggest, therefore, that if you postulate that the definition had said is, we wouldn't be here, because plainly you would then have to apply a test of coverage. Now, the other point that my lord put to me was that if it's right that the IMS data can be used to quantify the royalties, that would actually be a point against me, because it would show that niraparib may be used in ways that are covered by the patents. And we would suggest that that reading of may is tantamount to reading it as may or may not. In other words, it may do, it may not do in a particular case. It's possible that it will, it's possible that it won't. And we would suggest that if you seek to construe it in that way, that really is no different from striking out the words, because they actually cease to have any operative effect in terms of the contractual conclusion. It's just a piece of interesting background or explanation. And we adopt the point that my Lord Justice Arnold made earlier, that the parties, commercial parties, would not have deliberately included those words except because they were intended to have real meaning. Now, my learned friend sought to make an argument that you could infer what was the true meaning of the contract based on the size of the royalty. And he essentially sought to argue either you could have a larger royalty on a pay-to-infringe basis, so on a smaller base, or you could have a smaller percentage on a larger base on the basis of total sales. And your ladyship asked if there was evidence that that was the basis of contracting. Now, he took you to two things, which I entirely accept. First of all, in an email, Dr. Barton said, we are seeking a small royalty. And second of all, that Mr. Mulder said it wasn't that great. So in absolute terms, those labels have been applied by the parties. But my learned friend wants to go further than that, which is to suggest that the royalty would actually have been higher if it had been paid to infringe, and that it is lower in some way because it's, he says, total sales. Now, in fact, my learned friend, that's not a point, I think, that you see in the skeleton. It's not a point that's in the judgment. And my learned friend hinted at that case in the opening at the trial, and I objected to that point being raised, and that was on two bases. The first was they had never pleaded any factual matrix point of that kind. All of the points of factual matrix we rely on, they're all set out in our defense, patent misuse, the scope of the patents, and so on, the Barton emails. They had never advanced a case until the oral opening at the trial, that the size of the royalty was in any way relevant. And secondly, apart from the pleading point, there was actually no evidence at all before the judge, apart from those two items I've just mentioned. There wasn't, for example, expert evidence to say, normally it's X%, but here will be Y%. There was no evidence of that kind. So you couldn't draw any inferences. There was no material to draw any inferences. When we know what the actual percentage is, does that point in one direction or another? There was no evidence of that kind. Now, I made that objection at the opening in the trial. I don't believe my learned friend ever came back on that. And the judge obviously didn't make any finding because he didn't have any evidence to do it. And there's no respondent's notice. So that's really not a matter for this appeal. If I can go on to the Barton emails, my learned friend seemed to suggest that the meaning of the emails was a factual finding that the judge had made, which you could not revisit. That's a new point, I don't think, made in the skeleton. Now, in relation to that, there was only one piece of witness evidence about this, and it was our witness, Mr. Mulder, and again, probably we don't need to turn it up, but it's in the supplemental volume, tab 11, page 205, paragraph 19. And he simply says, I was informed that AZ had a policy not to make a profit on the royalty they charged, but merely to cover the cost of the royalty. It's exactly the same as what the email said. Now, my learned friend didn't cross-examine Mr. Mulder on that evidence, so that was unchallenged. And there was no witness at all from Astrazeneca, so Dr. Barton didn't come to give evidence, and she didn't seek to explain, insofar as that would even be relevant, what she thought she meant in that email. So one simply has what the emails say. The judge has given his interpretation. It's 2 lines. this court is in exactly the same position as the judge was to see whether his interpretation of the emails is correct. Now, in relation to the head licenses, my learned friend made a different point, which is he says that the meaning of the head licenses is a question of law, and therefore they cannot be part of the factual matrix. Now that's a new point in this sense. If you could look in the appeal skeleton at core volume 13, 167, this is my learned friend's skeleton. In paragraph 14, he says, the head license agreements are, as the judge found at paragraph 64, relevant as part of the factual matrix against which the license agreements were concluded. So his position in the skeleton was they are factual matrix. His position today is that they cannot be factual matrix.
He was accepting the point that I put to you.
I'm sorry. This
And
may
it's
all
not
be
necessarily a point against you.
no, indeed, and this may all be a storm in the teacup because I think he ultimately accepts you can look at it. So whether you call it factual matrix or not, it may not matter. The only point I wanted to make is at the trial, and we haven't got it here because I didn't know this point was going to be made. I cited to the judge's decision of my Lord Justice Arnold at first instance in a case which I think my Lord Justice Birss also did some hearings in. It's called Takeda Pharmaceutical Company in Figueira, 2017 EWHC 1995, paragraph 64 to 65. I'm sure.
I remember it well.
Well, I think it came past you in the interim applications list, so it may not have been. I suspect that it's a case all about an SPA, and about the background was Danish withholding tax. And your lordship made findings as to what is Danish law, and your lordship treated Danish law as an important part of the factual matrix in construing the clauses of the agreement. So the only reason I cited it at the trial was to say the law, a point of law can also be matrix, whether you call it factual matrix, but it's matrix background that's relevant to the interpretation
That's
of the
why
agreement.
you had evidence as to patent from US experts
Yes, indeed.
as to US patent law,
Well, exactly.
patent misuse.
Exactly. So that's admissible. Similarly, the meaning of an agreement, the terms of an agreement can be part of the background that's admissible to construe a contract. But since my learned friend accepts that you can look at it and that it can influence what you understand the sub-licenses to mean, this debate about whether it's really factual matrix so-called or whether it's simply another agreement that's mentioned in the sub-licenses to which the reasonable reader would therefore immediately turn up, it doesn't actually matter.
Right.
Now, he did make a suggestion that you should look at when in the course of the negotiations we saw the head licenses. Now, that's obviously inadmissible. No one ever looks at when did a piece of factual matrix come into someone's mind. But even if it was admissible, we agree with my lord's point that it wouldn't tell you anything because it may simply have confirmed what everyone thought in the first place. And my friend didn't take you to the head licenses. He didn't seek to make any argument that you can construe it as not being paid to infringe. This is an agreement to which they are a party, as my lord pointed out. They are a party with the head licensors. And if they say that it actually means total sales royalty, you would expect them to be able to take you to the wording in the contract that has that effect and to show that it does. And just as they did at the trial, they seek to say as little as possible about what the head licenses actually mean. His main point is he says that they don't actually help you construe the sub-licenses. We say it does help you, first because of what the Barton emails say about the relationship upstream and downstream. And even if we're wrong about that, it helps you because there isn't a calculation mechanism in the head licenses. Now, as to what, I think this is my last point, subject to Mr. Mitchison. As to the point that he raised that Astrazeneca has actually been paying the head licensors on a total sales basis, that is a complete red herring for a number of reasons. First of all, it's not admissible because we didn't know what they paid. It's not suggested that we knew. It's not a fact that was known or available to both of the parties at the time of the contract. What we knew was what the head licenses actually say. So we could read them and construe them, and we had the Barton emails, but we had no information at all about what payments have actually been made. And my learned friend has withdrawn his assertion as to what Dr. Barton would have had in mind, rightly so, but whatever she had in mind, that's not admissible. Now, second of all, the judge didn't make any finding as to the basis on which they paid. There's obviously no respondent's notice. But thirdly, the reason the judge made no finding is that there was no evidence at all before him, and that's why I intervened. There's actually no evidence about what AstraZeneca has been paying. Disclosure hasn't been given about this. AstraZeneca served no witness evidence. All there is an answer in a request for further information. And then the final point is that what my learned friend told you was the position when he made his submissions, and what they've said in the further information, is the basis on which AstraZeneca pays royalties on Lynparza, its own drug. And he made the same point again orally. He said, we pay on olaparib on a total sales royalty basis. Now, I have no idea whether that's so or not. There's no evidence or anything about that. But as I submitted earlier, the obligation to pay royalties upstream is not just on their own drug, but on our drug, Zedula. And even the further information and even my learned friend's assertions today don't deal with that at all as to what they pay on that basis. So there are really 4 different reasons why this has got nothing to do with the subject matter of the appeal. So I'll now cede the floor to my learned friend.
May I just ask you a question?
Oh yes, I'm so sorry, my lord.
I can ask it at the end, but it was to you, so if you don't mind. Can I just make sure that I understand whether it's in dispute or not, one of the points that your opponents were making. This is about the business where if you take, for the sake of argument, 3 patients and you each give them your drug in the hope that it will do them some good, one of them turns out to have been HR. I mean, if Mr. Mitchison's going to answer this.
Mr. Mitchison is going to answer that question, my lord, if you don't mind.
Well, I will answer that, and I was going to deal with the technical issues. That's not a basis upon which we say we shouldn't pay a royalty. The question about royalty payments comes from the scope of the claims. If you look at the scope of the claims, for instance, the ones I've showed you on page 126, for instance, the first one of the list, a method of treatment of cancer in an individual comprising identifying a cancer cell obtained from the individual as deficient in HR, etc., etc. So if you do that, you identify an individual who is HR deficient and you treat them. The fact that the poor patient may in fact not be successfully treated is neither here nor there to the scope of the claims.
I understand that's not the scope of that claim, but then that's your, as it were, positive case. But I want to understand what you say about the example that I put to your opponents, where the drug has been given without any testing to 3 patients, and it turns out at the end that one of them was HRD and the other 2 were not. Now, as I understand it, your position is that the one that was HRD, that was an infringement, which you have a license for, but the other 2, they were not infringements for which you didn't have a license for and don't have to pay a royalty on.
Well, with the greatest respect, that would depend on which patent we're looking at specifically, and what for instance, the second patent in the list says an individual comprising wherein said cancer has previously been identified as a cancer which is deficient. So it might be said that that claim is not infringed by giving the drug and only finding out afterwards that the patient was HR deficient. This is not something which we've considered. It would arise perhaps on something if we had a dispute about what is the right way to pay the royalties under the pay to infringe basis. But that is an example of where a claim appears to require prior identification before the patient is treated. And
it may be sufficient that it's been identified as a relevant cancer in a different patient. I mean, it all depends on how you construct
that's a possible interpretation. I accept that. And what I was going to explain to you, Court, is that Mr. Hoxie identified 7 passages in the 579 specification where he said that's where the test for identification is mentioned. And I went through each of those with him, and he agreed that there would need to be some sort of scientific procedure to do the identification in each case, apart from 2, which the judge deals with in paragraphs 60 and 61, and he dismissed Mr. Hoxie's suggestion that you didn't need some sort of medical or scientific procedure to identify the cancer. So the judge explains it's only a sort of tentative investigation into the scope because he only deals with one patent and he only heard from one oncologist on one side. But as far as he was concerned, you did need some sort of medical or scientific procedure to identify the cancer in each case. Now, I can understand an argument that says, well, it shouldn't matter whether the procedure is carried out at time point A or time point B, if that is the...
Yeah, but if one looks at subparagraph 4 of paragraph 56, a good response to platinum treatment was an example of the medical or scientific procedure involving identification. And the two key indications are that there is a response to platinum treatment. And indeed, in the EMA authorization, that's the only basis, because you don't have the third limb, unlike the FDA authorization.
That is right about the labels, my lord, but of course the labels weren't part of the factual matrix because they hadn't been conceived of on either side at the time that the contract was entered into.
To be sure, but the point I'm making is that at least in Europe, it may be different in the USA, at least in Europe, the difficulty may be more apparent than real because the authorization limits the cohort to those who are responsive to platinum treatment, and the evidence before the judge is that was an example of a medical or scientific procedure involving identification of HRD.
Yes, it wasn't in fact one of the ones that Mr. Hoxie identified. There was
Well, he
one
was
bit of
he
the
was
patent.
looking at the US patent.
Well, yes, but the judge was only dealing with the US patent here. Mr. Hoxie identified one passage which refers to cisplatin treatment in the patent, but that's exactly the passage that the judge says in paragraph 60 is not one that was relevant. So I accept these are points all to be argued at some date in the future if necessary, but I'm not in a position to go through every patent.
I do want to press you a little. I know it's late. I'm sorry. Do you accept that there are situations? What I'm trying to understand is at a higher level. I'm not trying to get into the weeds of those arguments. At a higher level, do you accept that it's legitimate to take into account the idea that there might be a need for some retrospective working out of whether something was infringing or not? Because that's the point that was being put at a higher level, which obviously I was interested in, as you can understand, and it's still not clear to me whether you accept that is a relevant consideration or not. I understand you can point to some of those patents that you currently can look at and say they're not retrospective, but it's not clear to me whether you accept the fact there is no retrospective.
Well, that with respect, that depends on each of the patents and whether the patents themselves require you to test the patient before you give them the drug. If the only basis that you could get a particular patent was by doing a test before treating, because that had never been done before and it wasn't obvious to do that, then we would say that's the way that patent should be interpreted. I don't know whether all the patents have that time point in them, and it may be said, if you look at it the other way, if you're talking about the practicality of the license and the 60-day point, then clearly we wouldn't suggest that if you haven't decided whether a particular patient is going to be treated within 60 days, then the royalty falls away. Of course, that would be an absurd suggestion, and not one that I think my Lord Arnold put it to my learned friend. We don't take the time point in terms of the calculation of royalties, but when it comes to the individual patents and whether there is a time requirement in the individual patents to identify a patient before treatment, that is, I'm afraid, a live issue which we haven't had to deal with at this stage of this dispute.
Okay.
No, and of course, as I'm reminded, there's no finding by the judge on this point either. And I was just going to, the final thing I was going to do was just remind your lordships and your ladyship of the paragraphs where the judge sets out what was known about other non-infringing uses. And I think Lord Justice Arnold has already put it to my learned friend, but it's paragraph 23 where he explains that what the prior art was in respect of the use of PARP inhibitors like niraparib, and it was known that they could be used to treat cancer in conjunction with other DNA damaging treatments. think you missed out that sentence with respect. And then the findings in paragraph 34 and 35, where he says that it would have been apparent to Tesaro that there were uses which were not infringing and which therefore they didn't need a licensed patent. And then the finding in 56.8, which I think I did refer you to this morning, where he says that Tesaro's belief that there were uses that would not involve infringement was therefore appropriately grounded in the wording of those patents as they would be read by an oncologist. So that was the state of affairs from a technical perspective as at 2012. What has happened since, by virtue of the granting of licenses, of course, a separate issue which is only relevant to the calculation of royalties afterwards, and not the interpretation of the license. Yeah. So sorry, the authorization only took place after, not the use license in the wrong context in this case.
Anything else? Thank you very much indeed. Well, thank you all very much indeed. You won't be surprised that we're going to reserve our judgments. I can't make any promises precisely when they'll be handed down. You'll be sent a draft judgment in the normal way for typographical and maybe minor inconsistencies, but not for future argument, please. If you could, each of you, remind your teams of the terms of the embargo, particularly in a case like this where there's clearly some sensitivities within the case, and ensure that we are provided with the appropriate lists of who's going to have access to the draft judgment. And if I can just make it clear for those all sitting behind and from the various companies, lists of 58 vital people are not what we have in mind, and very limited selection is what we have in mind. Any other matters I would hope we can deal with in writing, and I'd hope we'd all be able to agree in order at the end of the day. If I can just thank you all very much indeed. It's obviously involved a lot of hard work, and we're very grateful for the efforts that you've put into all the arguments and the preparation done by everyone involved. Thank you very much.